I will reconvene the June 6th meeting of the Lane County Board of Commissioners. Good afternoon. Welcome to Harris Hall. We have a pretty full agenda this morning, which includes executive sessions and returning to public sessions subsequent to that. It's 1:30 p.m. Item 15 is Public Works. This is an on-the-record public hearing. This is not business as usual per se. So I have a little bit of a script that I'll go through as we move into the on-the-record public hearing. In the matter of an on-record public hearing with the board adopting supplemental findings for a remand from Land Use Board of Appeals of a Board of County Commissioners decision that previously approved under Board Order number 1603-1506, concluding that a 2005 permit for school has not yet expired. The request from the applicant is the request from the applicant is the remand should be considered and decided by the Board of Commissioners as to whether or not the applicant has a vested right to complete the development of the school planning, file number, etc. Now, for the text of that, you can go online, hit view items, and you'll see the text of that. It's also contained in today's agenda. So we'll go through the procedural rules for a remand on the record for BCC public hearing. We begin the agenda item. I've read the agenda item entitled and the purpose and rules of the hearing. I'll take this slowly so that I can understand it. The decision is subject to criteria cited in the agenda cover memo and attachments, and evidence and testimony must be directed toward the approved criteria, and failure to raise an issue to enable a response may preclude the appeal to LUBA. The Board of Commissioners is the approval authority for these proceedings. The opportunities for submission of information and appeal. This is the opportunity for those present to enter information into the record. Because this is an on-the-record hearing on remand from the Land Use Board of Appeals, LUBA, any testimony or evidence entered into the record must be limited to the evidence already in the record. No new arguments may be raised beyond what was included in the LUBA record. Only persons who qualify as party may appeal the board's decision to LUBA, and I may need some interpretation surrounding that, Mr. Clark, as we move forward. Then I will call for disclosure of board members for ex parte contact and for abstentions due to conflicts of interest, ex parte contacts, or biases. Call for ex parte. Commissioner Sorensen?
I have none.
Commissioner Bozovich?
None.
Commissioner Lycan?
None.
Commissioner Williams?
None.
And I have none. Now, as far as personal conduct is concerned, no person shall be disorderly or disruptive. Audience demonstrations such as applause, cheering, and display of signs or other conduct disruptive shall not be permitted. This time, Mr. Mokrahajski, I'd like to hear the staff report. We would like to hear the staff report.
Thank you. I'll turn over to Deanna.
Good afternoon, Chair and Board of Commissioners. The board originally deliberated on this item at the March 15th hearing and approved the application. On February 23rd, Land Management Division received a request for remand from the applicant's attorney to proceed with the remand. And approximately a month ago, the application was deemed complete for processing. On September 16th, Land Use Board of Appeals remanded the appeal back to the county. LUBA's remand centered on one assignment of error. In March 2016, the board approved the request, concluding that the 2005 special use permit approving 3 buildings for a school has not expired. However, LUBA overruled this interpretation and concluded that the 2005 SUP is expired. LUBA explained their rationale against 2 criteria that's highlighted in the cover memo. LUBA also offered a disposition to the case. They believe allowing the girls' dormitory is not prohibited by law, but may be allowed under alternative allowances. What is before you today is similar to a request from the applicant via vested rights, which is a type of non-conforming use. The applicant has requested the board hear the remand, which includes supplemental arguments as described in the applicant's remand statement in regards to the vested rights case. A vested rights arises when a new land use regulation prohibits completion of a project which has been started but not completed. In 2005, the applicant obtained a special use permit approval for a school in the EFU zone, which included 3 buildings as characterized in the LUBA decision. The applicant applied for two of those three buildings, and the applicant is before you today to request a vested rights to complete the development of the non-conforming school as approved in the 2005 special use permit. The school became a non-conforming use in the EFU zone in 2009 when LCDC amended applicable rules and the legislature amended the ORS. In Oregon, key findings on vested rights is determined in past case law from 1973 and in 1981, which the main findings were laid out in staff's agenda cover memo. In summary of those findings, staff believes the evidence regarding the vested rights is substantial for a reasonable person to believe that a vested rights does exist. The director is recommending to close the public hearing but keep the record open. This will allow for additional argument to be entered into the record by all parties and to subsequently return on July 18th, 2017 to deliberate and take action on the matter. This date does support the remand timeline deadline and that the county has 120 days to make a final decision on the matter, which is August 26th, 2017. Staff would then return to the board with an order based off the additional argument received during the open record time period. So this concludes my staff report. At this time, I am available to answer any questions you may have.
Thank you, Dana. Questions, comments? I see none at this point in time. Then you're asking for us to close the record, close the hearing, keep the record open for a return on July 18th.
Correct.
For a discussion and possible action. Mr. Clark.
If I might, quick gloss on Deanna's report. The hearing today is an on-the-record hearing. The notice that went out indicated that there's no new evidence, but there would be argument allowed if this board wanted to hear argument pro and con. You referenced earlier the parties to the action in front of the board, and in my opinion, the parties are those parties that appeared at the Land Use Board of Appeals. Landwatch, Lane County, and McDougall Foundations, Inc. are the two other than the county that were present at LUBA. So those are the parties I think that the board can hear argument from. And on that point, the script you had earlier used the word testimony. I prefer argument because testimony to us lawyers means new evidence rather than argument as to existing evidence. And what we're talking about here is argument. The last point, just if it wasn't clear to the board to sort of tee up what today's about, the hearings official prior to the first appeal to this board ruled on a number of issues, including, I think, the vested right question, which is before the board. The board never reached that issue when it came to the board for its initial hearing. Instead, the board decided that the permit hadn't expired and therefore didn't need to reach this vested right question. That question is the only one that comes back from LUBA for today's hearing. So.
Thank you, Mr. Clark. Then I'll step through the process from this moment forward. Subsequent to the explanation, I will open the public hearing. We will hear the applicant's testimony, and then we'll hear the testimony of persons in favor, then testimony of other persons, additional comments by staff or council, and then a rebuttal from the applicant. Am I correct in that order, Ms. Wright? Thank you very much. Then at this point, I will...
And we're not getting testimony, we're getting argument.
Argument, exactly.
Yeah. Okay.
Precisely. Thank you for that clarification, Commissioner Sorensen. So, Mr. Clark, anything else I need to note before we proceed? Then I will, I'm going to open the public hearing and order of procedure. Excuse me, open the public hearing. I've already had the order of procedure. Thank you. Once again, this is not exactly the way we conduct these public hearings. This is an extraordinary situation. Public hearing is now open. I'd like to hear the applicant's testimony.
Argument.
Argument, thank you. Change that word.
Argument.
Commissioners, Bill Close here to make argument. Argument only. Appreciate the staff report, both parts of it. Totally concur that this is an on-the-record proceeding, really at our request. And everything I say to you that may sound factual is based on the record. If I make any mistakes, please disregard anything that's not already in the record. If I could start with, it's been 2 years almost since we were here last talking about this last things move slowly. if I could start with the big picture, this is about a school that's fully operational, partially constructed. The school lives on a 2-acre piece of concrete in Jasper. That concrete is zoned exclusive farm use. And before the school could be fully constructed, the state rules changed, which meant the county rules changed. So when the school showed up for the next building permit to finish the construction, county staff said, the rules have changed. State law has changed, county law has changed. There ensued a long discussion, and it was concluded that the applicant should file for we requested non-conforming use determination. We thought it was really a vested rights determination. We filed for a non-conforming use determination. The matter got to the hearings official, who said you really were correct, needed a vested rights determination. That's how we got to the hearings official. From the applicant's perspective, the school operator's perspective, after we realized that the state law had changed and the county law had changed, and the change really was to the wisdom of the legislature. They decided that you couldn't have a school on EFU land anymore within 3 miles of an urban growth boundary. And the statute that made that change included a little escape hatch that you could come in if you were already underway and you wanted to expand or finish. You could come in and ask for what's essentially a special use permit issued under state law to finish your school. And having looked at those standards in that little special use permit escape hatch to finish the school, we decided that looked pretty discretionary and it was probably going to attract flies, and we really don't want to litigate. We just wanted to get the school built. So we decided we had several ways to get the school finished. One way was to argue that because the school construction and use started while that first permit from the county, land use approval from the county, was in effect the first 2 years, that we're allowed to keep getting building permits to conclude. That went over pretty well with the county planning department because there are hundreds and hundreds and hundreds of, I don't want to exaggerate, there are hundreds of citizens, voters, who hold permits, land use permits, to develop something on EFU land, who have started that process but not gotten their last building permit. But the county historically has continued to issue building permits so long as you started your construction process during that 2-year window where that state permit was in effect, that initial land use approval. What we've learned, of course, now is that's not true. So that was our one way to get through the hoops, which was just to keep getting building permits because the county was comfortable that we had started our construction during the tenure of that 2-year land use approval. Our second theory for getting the school finished was that, well, we had a vested rights. Even though the state changed the law, we had enough invested in the school, substantially constructed, that we were entitled to finish out the construction even though the state law had changed. That's the vested rights theory. The third theory for finishing the school was the little carve-out I discussed that came with the statute that says, well, if you have one of these uses as existing, you can expand it or complete it if you meet these special standards. That's the state special use permit approach. And the fourth approach to finishing the school would be to draw a line, bright line, come back to the county and say, county, well, our school is built on a 2-acre chunk of asphalt in the EFU zone, so really that chunk of ground is not EFU land. It's physically developed and committed because it's not farmland anymore. It used to be a log yard for the mill that's across the street. So we would come in and ask for a plan amendment, which was really an exception to the Goal 3, and that exception would say that this property is no longer usable for farmland, it is concrete, and therefore we're allowed to have a change to, say, rural residential. And if we were to change your rural residential, we could finish the school no problem because the new state law doesn't apply to rural residential property. It just tries to save agricultural property, including 2-acre chunks of agricultural concrete. So those are the four ways of getting through the mix. And so we started at the front of those four, and we said, well, to the hearings official, we started our development of this school during the 2-year tenure of that land use approval, and therefore we're allowed to continue. And the hearings official said, no, that permit expired. You didn't extend that land use approval. You're out of luck, which was quite the surprise. We brought that issue to the county board, and that rung true to the county board. You folks are really genuinely excited about that theory, and you said, go forth and finish. This is a really pretty simple matter. The board never got to the second theory, which was the hearings official saying, you don't have a vested right either, people. And the hearings official said, you don't have a vested right either, because the hearings official looked at that school and says, this is really a 3-phase school, and so we can segment it. And yeah, you finish the first phase, that's good, go in peace. You have the first phase of a school, that's all you get. Our pitch to the hearings official was, well, no, it's a single school that we're just developing in 3 phases. So when you ask the vested rights question, the issue is really, have you developed enough of the single school that you're allowed to finish it under vested rights theory? It really came down to, whether you think of the school as 1 use or 3 uses. And we lost on that at the hearings official. We brought that issue to the county board. You never got to it because you gave us an escape hatch on the first theory, which is you started building during the 2-year tenure of your approval. So go forth and finish your project. So here we are back from LUBA. Landwatch, I believe, filed the appeal to LUBA, and the positive side of that appeal is that this little body of law was really clarified. We now know that if your constituents get a land use approval to do something on farmland, it's going to be good for 2 years, and either they better finish it during that 2 years, or they better ask for an extension, or they're going to lose it maybe before they're finished constructing it. That is something every one of your constituents ought to know when they get a land use approval to do anything on farm or forest land in Lane County. So there's a plus side to all this litigation and the 1.5 years that we've wasted here in the recent past. So now we are back asking for a determination of the second issue that was on appeal to you 2 years ago, which is whether or not we have a vested right to finish this use based on the work that was done under the initial building permits that were issued during the 2-year tenure of the original land use approval. What's changed in the last 2 years is, in your first decision, you made a finding that this was 1 school, people, not 3 things, discrete things. That was very important to us, and LUBA affirmed that. So we come back to you with a correction of the hearings official's decision. We now know that this is a single project, and then for purposes of the vested rights analysis, we can say what percentage of the total cost of the school was expended under those initial building permits that were issued during the first 2-year period while that land use approval was in effect. And we're at about 1 to 8, like 1/8 of the total cost, which is way above the level of expenditures that the Supreme Court has said are the basic test to determine whether or not you have a vested right. So to drop back again, I'm almost done. We're asking you to work with the existing record and LUBA's decision and find that the hearings official erred in concluding that we don't have a vested right. In fact, we do have a vested right to finish this use. That's pretty much it. We've submitted draft findings, which every time I read, I find some more little typos and nits that need to be picked. The only other issue which, on reflection, I think ought to be addressed in the findings is a defense that was raised by Landwatch when they filed their 2-page letter on the day of your hearing 1.5 years ago. What Landwatch said was, you lost your vested right because the use ceased for more than 1 year. And in their view, the use that ceased was the construction activity. And we think that they read the code wrong. We've briefed this, but when we read the code, we think the code says you lose a non-conforming use if the use ceases, and use means what you intend to do with the property, and that's a school. And that the code fairly read does not mean if you stop constructing for a year, you lose your non-conforming use. It's all about the use. It's not about the construction. I think that's it. I was going to try to take 5 minutes. I was probably 5 1/4. I'm sorry.
You're in the window.
Or 15.
At this point, are we open for questions, Mr. Clark? Is that, no questions at this point then? Thank you, Mr. Clues.
Thank you.
Then we will have arguments of persons in favor. Any arguments there? I see none. Any arguments from other persons? I see none. And then additional comments by staff. Council.
Hold on.
I thought you meant neutral.
What we want to hear from is the other party to the action, which would be somebody from Land Watch.
And that's listed as other persons in my script. And then testimony for those in opposition, other persons, at this time.
Argument.
This is arguments. Please state your name for the record.
My name is Lori Siegel, for the record, on behalf of Land Watch at P.O. Box 5347. First, I'll say that because the remand hearing is confined to the record, Land Watch incorporates and relies upon its prior testimony and evidence contained in the record. And that's all we have to say about the record. Mr. Clark noted that that the definition in his opinion was of parties, whereas limited to those who argued before LUBA. If that were to be the case, the only party here would be Land Watch, because the applicant did not argue before LUBA, they did not show before LUBA, and the county did not defend their own decision before LUBA. And regarding how long it's taken for this to get through the process, I just wanted to point out that Land Watch hasn't requested any extensions or asked for any timelines to stop all the extensions and additional time. We're at behalf of the county and the applicant. Thank you.
Thank you. Any further testimony, arguments from other persons? I see none. Then additional comment by staff or council, Ms. Wright? No further comments? Mr. Clark? Very well. Then rebuttal. I see no rebuttal. At this point, then, Mr. Clark, I'm going to close the public hearing. But the record will remain open, and upon closing the public hearing, it's been requested that we keep the record open and return on July 18, 2017 for deliberation and action. So I will close the public hearing. Discussion by the board.
Would you state the date, if you don't mind, Commissioner? The record is left open until...
Will do. Thank you very much. That's the August 26th date.
June 20th, I believe.
June 20th.
The record is open on this case, as I understand it, until June 20th. Thank you.
So then we have an option to close the hearing, keep the record open until June 20th, 2017. Very good.
Is that,
Commissioner Bozievich.
can I clarify, do we need to actually have a motion to close public hearing and keep the record open until June 20th?
That would be best to clarify.
Okay. Excellent. Commissioner Bozievich.
So I'd like to move to close the public hearing and keep the record open until June 20, 2017, to allow for additional testimony or evidence, I should say additional arguments on the evidence already in the record, and to return on July 18th, 2017 to deliberate and take action on the matter.
Second. Moved by Commissioner Bozievich, seconded by Commissioner Lycan. Is there any discussion to the motion? I see no discussion. I'll call for the vote. All those in favor, please say aye.
Aye.
Opposed? None. Passes unanimously. Thank you, Ms. Wright. I'll give the room a moment to clear. Then we'll move along, Mr. Mokrzycki, to a report back. Appeal Trends in Lane Management Division, PM and NBA 11/29/2016. Today we have Ms. McKinney. Mr. Mokrzycki.
I think that's meant to say land management. In
Yes,
Lane County.
indeed it is.
Okay,
Meant to say that.
Thank you.
so I'll turn it over to Ms. McKinney for an overview.
Thank you. Thank you, Commissioners. Excuse the typos. Like Mr. Close, I often reread documents that I've written and say, oops, as I read them. So we're here today to report back on an item that the board discussed in November, I believed, in response to a letter that Mr. Close sent to you and me in regards to the appeal trends in Lane County. And so in November, we brought before you some information. We put together the best that we could with the data that we have. And it allowed us also to sort of look at the appeal trends, because there's, reality and then there's the perception of reality, and they're not always the same thing. But what we found in November is that there really had been what seemed to be an increase in appeals in 2016. So in coming back to this item, one of the things that you've heard me say before is that the Land Management Division has made a concerted effort to work with anyone who wants to work with us, right? We're very open, we're transparent, and we began having some conversations with Landwatch Lane County, which, as I understand it, hadn't previously happened. And the intention, I think, from both sides, from the side of Landwatch and from the side of the Land Management Division, was and is to really cooperatively and collaboratively work together. And what I find when I talk through issues with a lot of people is often we may be on the same side of things, but we might disagree with the details. And so I've really appreciated that conversation and that ongoing relationship, which I think is of value to me personally and professionally, but also I think to the county and moving forward. So what Tim Elsey, the Public Works Director, and I discussed and agreed to is we wanted to honor the discussions that we'd had with Landwatch Lane County earlier on this year, where we sat down and talked about, what are the issues that are being appealed? Can we, again, kind of resolve some issues at LUBA and expect a decrease in the number of appeals? And that was what we understood. And again, what when we met with the folks, that was their intent. And so our intent was to come to you and say, we want to wait a little bit more time to be able to see the data. And that's still in some ways what my recommendation is as the planning director. We did pull some data. You have received a number of comments, including one that came in shortly before I was walking over here from Sean Malone. There's, some misunderstanding out there and some misinformation, but again, what I'd like to state for the record is a lot of the information in Mr. Malone's letter, which basically claims that the information that the Land Management Division put together is utterly false and can't be relied upon. That letter was a surprise to me, especially considering the, I think, goal of our discussion with you today, which is to really be able to say, do we want to make changes to the fee structure? Because again, that's the crux of the issue here, is that we have a $250 appeal fee for our second appeal. But before we get to that and to the board's discussion on it, because I think really we're here to answer questions and to have a conversation, but I wanted to take this opportunity, if I could, turn around and hope that behind me is Gary Darneal. Yes, indeed, he is. I'd like to ask him to come up. I just want to introduce, because he doesn't come before you, Gary Darneal is our hearings official. He's been our hearings officer for a number of years. He teaches land use law, I believe. He reminds me that he's taught it to many students. I didn't go through his program. Has done work for us for a number of years. I also wanted to thank him for, he's not going anywhere, he's still our hearings official, but I also wanted to introduce Ann Davies, who is now working with LCOG. So some of you may have been familiar with Ann. Ann actually, I think she used to work at LUBA, or LUBA as I like to call it. But Ann comes with years of experience in the land use world, and she's now working for LCOG rather than the City of Eugene. And so both Gary and Ann, Gary's the hearings official, but Ann is starting to do some work with us as well, sort of either under the hearings official contract or some other. She's helping staff review codes. So again, I just wanted to take this as an opportunity because you don't see Mr. Darneal's face often, but you do see his decisions. Obviously the ones that have the hearings official's name on them are, not all, but most of them are done by Gary. And if the board wants to direct some questions and conversations, again, Gary's legal mind and understanding of these issues is very, very deep. So again, I hope you will excuse me for taking that opportunity, but I did want, again, a chance to bring Ann here to meet you all because we will be working with them in the future. So with regards to the discussion today, really for the board to consider is the direction originally was should the land management division, should we look at raising the fees? Because again, to be clear, there's a $250 state mandated maximum for the first appeal. And so of course we comply with that, the first appeal. And those appeals either go to Gary or to you. It's the second appeal. And so again, this item that we're talking about specifically is the elect not to hear. Right now, that's $250, and many of you are familiar with the history. I mean, that was changed several years ago to provide access in some ways to be able to try to bypass the board where there were issues, as there often are, that sometimes they're state issues, right? And we really need to hear from the state because it's state law, and sometimes it's lane code issues. And in those cases, we always recommend that the board be the final say on that because it's our code. So the elect not to hear was supposedly this, not a very time-consuming, easy, quick process that we could do for $250. And the fact is that it does take us more time than $250 covers. That's, I'm not weighing in one way or the other, but that just is the fact of the matter, is that staff does take a considerable amount of time just to prepare a packet and come to the board. The trend in the past, I would say since I've been here about 18 months, is for the board to concur with staff and the hearings official and to indeed elect not to hear and then to move those decisions to LUBA. Some of those decisions have been made and again have changed either Landwatch's perspective or our perspective. If there is a decision by the state that says what the state thinks, we don't choose whether or not to comply with that. We must comply with that. There was a conversation in one of the letters about the fact that land management staff is making bad and incorrect decisions and that we need to be trained, and so that this is an opportunity for us to get training sort of through this appeals process. And again, I just want to be very clear that we try our best to follow the law as we understand it. Planners don't actually participate in this sort of appeal in a way that it's a learning opportunity. So there's other ways, and we, like most professionals, make sure that our credentials are up to date and that we're using good information. So I know I've been a little bit all over the place. There's been a lot of information that you've received in the past few days about this. The final thing I will say is that the way that we described this was for a work session. We really aren't here. We didn't have a public hearing. We didn't provide neighborhood notice about anything because what we're here for is to receive direction from the board about whether you'd like us, as I said, to continue to sort of wait and see for maybe 6 more months to see if the numbers start dropping and give Landwatch the opportunity to demonstrate that this really was an anomaly. Or does the board instead want to direct staff to look at raising those fees, and then we'll come back before you with specific manual and code changes? Thank you.
Excellent. Thank you, Ms. McKinney. Ms. Darneal, Ms. Davies, anything you'd like to add?
I don't believe so.
Okay, very good. Then I'll open it for questions or comments from the board. Commissioner Sorensen.
I noticed in the memo that the Land Management Division prepared, there was a table of the appealable land use decision, land use applications and decisions and total appeals. I was just wondering if one of the allegations here is, on maybe unstated allegations as well, people are appealing, but they're not really appealing anything legitimate, that their appeal is just to drag things out and they don't win on their appeal. And I thought it was interesting that this table, which shows that, basically there's 62 appeals filed, they're ranging from 0 total appeals in any given month to 8 total appeals. And in terms of the total appeals from January of 2016 through April of 2017, there's 46 land watch appeals and 62 total appeals. So what I thought would be maybe helpful to me is, and maybe the rest of the board would be, well, what happened to these appeals? It's not the total number of appeals, it's what happened on the appeals. Because if every appeal, in my view, this is just from me talking, if every appeal were lost, that would be different information to me than, well, some appeals are successful and some are unsuccessful. So to me, the putting the barrier up and putting the fee as a higher and higher number means that citizens may be denied access to the opportunity to review what the government's done. But it would be useful for me to know when the appeal is, let's say, reversed, or the appeal is in favor of the citizen against the government. How often does that happen? How often? And I guess I'm not asking for anybody to invent some data on the spot or even comment on data that they haven't had a chance to review, but I'm interested in knowing that. The other thing is that the focus seems to be on Land Watch rather than the people that Land Watch is helping. And I'm just curious, because there's obviously people that go to Land Watch, and that's in our record, that people go to Land Watch, and even they go to the county, and county staff says, well, gee, we can't do an appeal for you. You have to go to a group. And at least one of the letters or emails I read was that county staff say, well, one group you can go to is Land Watch because they help people with appeals. And I've heard that here at our table, that commissioners have been approached by people and they say, well, hey, look, I'm a Lane County commissioner. I don't run around appealing land use decisions, but you might want to consider calling, Thousand Friends of Oregon or Land Watch Lane County or other groups. So I'm just, and it looks like you might have an answer for me.
Well, I'm going to let Keir give the answer on the numbers because he's the numbers person. He has some more data.
And I'll just ask that whatever you're telling us right now, I'd love to have you send us an email so that we don't have to try to keep track of this while you're talking.
But what I'd like to say before Keir starts is just very quickly with regards to your second comment. And there has been some question, and we thought about, we're not trying to target Land Watch, and so it isn't meant to be a negative assumption. I mean, you're right, Commissioner Sorensen. Land Watch represents generally other people, other neighbors, and they are, as I said in November, they're an organization that does good work that we respect, that again, it's good to have those both sides of the perspective, right? So that we're, to the extent we can, be working together in agreement, and where we can't, we use the legal system to address that. But I just wanted to put that little bit of context about, and again, I think it's made some people feel like there's a anti-Land Watch sentiment from the Land Management Division. That is certainly not the case. So if there's any questions about that, I just wanted to clarify. Keir?
Ms. Miller.
Thank you, Chair Farr, and good afternoon, Commissioners. Again, for the record, my name is Keir Miller, Planning Supervisor. Commissioner Sorensen. So to try to respond to your question, and we can follow up with documentation, but some of that documentation is already in your packet. As Lydia mentioned, this is the second time we've been before the board to discuss this item. The first time we provided a more thorough analysis of the appeal data going back 7 years, and that we've re-included that into your packet today. That's included as attachment A. And I just point to, let's see, it would be this, there's a table, the second to last page of attachment A. It's basically the 2010 through 2016 data that lists other counties and their appeal figures, and the last column of that discusses the number of appeals that we've received and what their ultimate disposition was. And the reason we didn't follow up with the additional information to build on this in the last 6 months or so is because a lot of the new appeals that have come in haven't been determined. They haven't been decided yet at LUBA. So if you look at that data, it basically says that 10 of the appeals were dismissed, 6 were affirmed, 14 were remanded because of issues, and 2 were reversed. So in 2 instances, the county was completely reversed. In 14, there was some issue. It may not have been, a fatal issue with the application, but it needed some work to be remanded, to be dealt with by the county. So those are the numbers going back 7 years. But this doesn't reflect, as Lydia mentioned, the kind of increase in appeals that we've seen, a pretty dramatic increase in the last 6 months to a year. And we're still waiting to see that data. Some of those cases have been determined which aren't reflected in this packet, and I can certainly follow up with that. Just off the top of my head, I think a couple of those the county's been affirmed on. There may have been a withdrawal, and we may have been remanded on one of those recent cases, but I can follow up with more information on that.
And if you'd entertain, I think Gary Darneal might have some information from some of those decisions since 2016.
When I saw Landwatch's table, I was interested in seeing which of these decisions that LUBA ruled on were mine. And since 2016, only 3 decisions have been looked at by LUBA. One was affirmed in 2016. It was a forest template dwelling. One was affirmed in 2017, which was a zone change. And one in 2016 was dismissed on a motion by Landwatch. That gives you a summary of the most recent decisions from the hearings official that have gone up. Now, there's a whole slew of my decisions currently before LUBA, but those are the only ones that have been ruled on since 2016.
Commissioner Sorensen, with the subsequent email, does that cover your question?
Yeah.
Very good. Commissioner Bozievich.
Thank you. So I want to get a little bit of clarity as we look at the first table where it says that's in the body of the staff report, not attachment A. When it says decisions issued and appealable land use decisions, that covers a wide range, doesn't it? Does that? So what are some of the, because a lot of times we're hearing, forest template dwelling zone changes, special use permits being appealed, but when you start talking about, only 62 out of 342, what are some of the decisions that typically don't get appealed? I mean, that are considered an appealable land use decision?
That don't get appealed?
Yeah, I mean, like special use for home occupation.
I think we could provide that data. I mean, you're right. We have this number represents appeals of property line adjustments. It could be legal lot verifications, everything from that to a plan amendment zone change. So again, if you'd like us to provide some of that data, we can pull together the numbers. I think as, we have seen a reduction in our forest template appeals, for instance. We have made some changes with regards to how we do property line adjustments based on a recent decision. And that decision, again, as it's found by LUBA, that's how we apply it. If that decision stands, we will continue to apply it that way. But I don't have that up off the top of my head, Commissioner. Again, if you'd like, here and I can follow up with some specifics.
I just Having done a home occupation special exception, I do know it's an appealable land use decision, so that would count as one. And when I renewed it, it would count as one again, because that's the renewal is appealable. So, so when you start making a comparison between total decisions and appeals, please remember that a lot of the land use decisions we make are very routine, but they do have an appeal process because there could be somebody aggrieved. I mean, a home occupation could be something that a neighbor, disagreed with the decision on. And at that point, it's a director's decision that would be appealed to the hearings official, and then would be subsequently appealable for an elect to hear. So that's. I would caution people looking at those numbers and saying, well, not very many of our decisions are actually appealed. It's surprising that as many as we have are appealed because so many of our land use decisions are what I would consider fairly routine and non-impactful to a neighbor.
And I would just note on that, I've been meeting with the City of Eugene Planning Director a number of times, and we've been having some conversations around a package that will be before you. And the numbers in Eugene, I was interested to hear. They issue 200 and some odd land use decisions compared to our 300 and some odd, and their appeal rate is 2. So for last year, it was 200 and some odd decisions that were issued and 2 were appealed. And again, that was surprising to me, hearing some of the things that I've heard about the city of Eugene. So just
and one of those was the Oaks at 14th. So
that is
the use there was what was driving that appeal. So I just wanted to bring that out a little bit because it's really important to understand what we're dealing with here. And then when we get down to the 62 that are actually appealed, when we talk about, 16 of those last year, or in that time 7-year time span, were remanded or reversed. Reversed is obvious that there must have been a significant error in the decision that LUBA disagreed with in our interpretation of land use law, state land use law, that they reverse it. Remand does not necessarily mean that Lane County erred in approving it. Quite often the remand is you just need to shore up a finding on a specific issue and then we're okay with it. And I've seen remand decisions from LUBA that simply come back to planning staff. Planning staff writes and rewrites the findings with a couple changes here, to wording, comes back to the board to readopt those findings, and LUBA approves the land use decision. Not that we actually erred in approving it in the first place. So the fact that there's a remand does not necessarily mean that we didn't interpret land use law correctly. We may not have just provided the correct terminology in the findings, or the findings just needed some kind of refinement according to LUBA. So I just want to clarify that, because that's where I start getting into a little bit of a gray area here. I kind of look at this as I don't necessarily just want to raise the fees to try and prevent frivolous appeals. What I'm more in favor of is trying to set up a system where if you appeal and then we're affirmed or remanded for a not, that they affirm, they agree with the decision, they just remand for additional findings, that there be an initial fee collected for me that actually would get back some of our costs. Because what the real issue here is, we're collecting $250 for something that's costing us thousands right now. And because of that, we're not having the staff time available, because we're expending resources that we're not collecting fees on. And this is a enterprise function, where the land use division lives off their fees. We're not getting the code changes that we want to get to here as board. We had a discussion this morning about camping ordinances and our limitations on being able to address those because of staffing. Well, if we're not getting recompensated for the cost of appeals, we're not able to staff to do those code changes we really want to get to. Whether it's marijuana updates, whether it's camping ordinance updates, or whether it's just cleaning up our darn code that's a mess. We're eating up staff time uncompensated on elect to hear appeals right now. So what I'd like to see us get to is a fee that is refundable if you prevail. But the problem I have right now is in that discussion I just had is how do you determine who prevailed? I mean, it's obvious if a reversal is an obvious prevail. Affirms an obvious not prevail. Remand is a very gray area. This last remand, I would probably, that we just finished discussing on Laurelwood, I would say was prevailed on the appellant's part, because we made a decision that said the permits had been, that they didn't expire, and LUBA determined they hadn't expired. Now, we still can approve that use, but we're not approving it on the basis we originally did, if we agree to the vested right. So that one, pretty clear. I've seen other ones come back where it was just a matter of clarifying a finding and sent it back up and it was okay. It was just they didn't like the wording on a finding, basically. We had actually, the basis of our decision was correct. So who prevailed on that one? So that's where I struggle with this. I do think we need to consider raising our fees so we aren't subsidizing, just like we don't subsidize developers in our application fees, we shouldn't be subsidizing the folks that are appealing with our fees either, unless we erred. And then I think we should be able to say give back all the rest of the fee with the exception of the original $250. Keep something in there, but that's where I land on this. It's a difficult discussion.
Thank you, Commissioner Bozievich. Commissioner Williams.
Thank you, Mr. Chair. First of all, I'd like to thank Mr. Bozievich for putting things so concisely in perspective. You stole just about every one of my talking points, but you did it probably better than I could myself. I do have a question, though, that do we have a sense for just exactly what the dollar amount is for the staff time and other incidentals between the $250 fee and the actual expense that we're talking about?
Thank you, Commissioner Williams. We did do a fee study that was done by a private consultant a few years ago. And if you look at those numbers, it could be argued that that might cost the Land Management Division up to $3,000 or $4,000 when you consider our staff time, the time to come here, the time to confer with our legal counsel. But as Commissioner Bozievich and others have noted, it's not really this elect not to hear is difficult to put a dollar amount on. We certainly spend more than $250 just to put it back it together and show up. We had originally thought that maybe a $600 might capture the elect not to hear. But again, I think we'd want to do some really more detailed analysis. What we do have is we have an elect not to hear, which is $250, and then we have an elect to hear, and that is actually set up in a similar fashion, I think, where it's $3,000 some odd dollars. You might know the details. And then depending on what happens, if the board elects not to hear, then the applicant can receive some additional refund. And so we could look at doing something similar here. But that's the tough question, is we could say on average what the costs would be. It's going to be somewhere between $250 and $3,000. It probably realistically does, take several, hours of time. And so I think we should come back with some specific numbers if you're asking for that, have some data run. But I would guess it's between $1,500 and $2,000.
Thank you for that. So if that could be extended out to the number of occurrences that this occurs, if there were and I realize this is sort of a nebulous number out there, but I'd like to have some sort of, I guess, best guesstimate of what those expenses may be. And I guess my last comment on this is the issue of what appears to be a subsidy and how that is fair to the taxpayer that is picking up the slack for the differential between the $250 and whatever that other number is. And so those are my concerns. Again, I'd like to thank Commissioner Bozevich for his comments. Thought they were spot on.
Thank you, Commissioner Williams. Commissioner Sorensen?
Sid hasn't gone yet.
Okay, Commissioner Lycan, then Commissioner Sorensen.
Okay, thank you, Mr. Chair. Lydia, my question is, and I'm trying to figure out how to clarify this or ask this. So give me a garden variety idea of what you see as far as an applicant is concerned. Because I'm guessing you don't see a Royal Caribbean Cruise Line, you don't see a Symantec, you don't see a Franz Bakery, you don't even see a regional hospital for county applications. Is that correct?
Yes.
Is that safe to say?
Sir.
Is it mostly residential?
No, actually. I mean, I think a lot of it is on EFU or forest as well. It really depends on the issue.
And what's a typical, or what would be a common development that would occur on EFU?
Well, EFU is set up for farming, so that would be the kind of development. When you say residential, perhaps this is what you're getting to. There are often allowances to add a dwelling. And I think, again, or to divide property to adjust property lines. And I think that's where Land Watch really pays attention because, like the county, they care about preservation of farm and forest land. So when they see applications submitted to us and being approved that essentially allow a higher development of residential development on farm or forest land, that's their concern. So perhaps that's what you meant by residential.
No, and it is. And the reason why I'm asking this question, because I think another common piece would be somebody buys a piece of property and then make a decision that maybe they're going to do a property line adjustment, do a zoning change to allow their kids to build on that property in the future. Isn't that something you see as well?
Yes, we do.
And do you believe that it would make sense that even though this has not occurred in 30 years, and I probably don't expect it to anytime soon, but don't you think it makes sense that the legislature should maybe address some of these issues? Because after all, if you look at SB 100, what was the protection in place for? We used to actually do forest management the last I checked. And a lot of those protections were actually in place to protect those actually doing forest management. We're not doing that anymore. And so I also look at some of we've gone through these issues with those folks who wanted to put in I'm just going to paraphrase, wedding event planning, because there's money to be made. There's opportunity. I'm curious, have you received any appeals for marijuana growers?
I actually don't receive a lot of complaints, but
so nothing by Land Watch on marijuana growers. I'm just looking out there. Have you? Okay, got it.
No.
Okay, I was just curious to see if that's the case because after all, that's an ag business.
It is an ag business. It's permitted outright on EFU. That's exactly.
Because we're seeing some folks that have been in the seed business and other types that are getting involved in this and probably would never even smoke it. Probably would never care. There's money to be made. And you've been at this for, I would say, a long time. And I'd actually asked Mr. Darnell and Ms. Davies to comment on this as well. And that is, do you believe that there should be changes made at the legislature to address the changes that have occurred in the state of Oregon since SB 100 was put in place? So again, you have SB 100, you've had some changes made to it, but for the most part, it's remained fairly consistent for 44 years. I'm going to tell you right now, if I were a business and I remained that the same and never changed for 44 years, I'd have been bankrupt 42 years ago. So, and I'm speaking at that from somebody who has actually ran a private sector company and has been in that position and has made dramatic changes to keep up with competition. I'd just like to get your thoughts as well, because I think it goes much larger. It's a much bigger issue than what we're discussing here today. And, you know, the legislature did go through what we called the big look. We actually, and when I was still mayor of the city of Springfield, we called it the little peek. Because that's all it was a peekaboo. There was no big look. It was the most ridiculous thing I think I've seen. You know, you had this really incredible thing. Oh man, things are going to finally be addressed here, and it turns out it was just a peekaboo. I'd like to get your thoughts on this, and Mr. Darnell in particular. I mean, you've been doing this a long time, and you I respect you greatly as our hearings official. I think you've really been I would rate you as well as anybody in the state, and believe me, my family is developed in every part of the state of Oregon, including Central Oregon. By the way, a lot line adjustment in Illinois takes 1 week. Just thought I'd let you know that. We have 40 acres of developable property in Illinois. Took us 1 week.
We can do it over the counter.
Thank you, Commissioner Lycan.
But I'd like to get Mr. Darnell, if you wouldn't mind, just and Ms. Davies, if your thoughts as well, because I think that a lot of these issues, and I know I'm kind of getting off topic here a little bit, but because we want to focus on the fees, but it's a much bigger issue than just what we're talking about today, and I'd just like to maybe get your thoughts on this.
Commissioner Lycan, I was in law school when Senate Bill 100 was passed, and then went into planning school for a master's degree. And I would have to agree that there's been no overall major changes to the legislation. Each year you see some tinkering. You'll see additional uses allowed in the EFU zone. You see problems that the counties and the cities have faced slowly getting up to the legislature and being addressed. I believe this year the legislature is looking at some fairly drastic reduction in regulations to the state or the counties east of the Cascades. Mm-hmm. Now that would be a major change if it occurs.
If it occurs.
And I have no idea what its likelihood, but no, there hasn't been an overall comprehensive look at overhauling the land use program.
And Ms. Davies, anything you want to comment on, or I'd appreciate it.
Yeah, no, I mean, I agree with that as far as an overhaul, there is tinkering plus every single legislative session. There's always a big land use bill, and there is, I don't think the big bill is 2007 this year, but I don't think it includes the Eastern Oregon bill that Gary's mentioning. But I do think that there are a lot of the issues that Landwatch Lane County are concerned about, or at least they say they're concerned about. A lot of those I think can be addressed at the legislature. I don't know if they've considered hiring a lobbyist or whatever, but some of the code provisions that we have, they're either, subject to interpretation that gets us in trouble, that the legislature could make clearer so we don't have to be doing these fights. If we could get the legislature to make them a little more clearer, then Lane County wouldn't have to be fighting with Landwatch over what they mean. That's doesn't require an overhaul. It requires someone to actually look at those issues that Landwatch is interested in and go to the legislature and see if they can get some of those figured out so we don't have to be spinning our wheels down here.
Well, and I appreciate that. So, Mr. Chair, thank you for the lax on this. And I know we're focused on this particular topic, but the point I'm making is that it goes much larger than that. And I like what you said, Ann, because I think you're absolutely correct. I think just some little tinkering could be done at the legislative level that would help alleviate a lot of the issue that's going on right here. And that's what really is frustrating to me as much as anything. Now, on the topic itself, when I was looking at the one table, so 380 applications, 62 appeals, 46 by Landwatch. So that comes out to about 16% total in appeal. Landwatch is appealing out of that 16%. Landwatch is involved in 71% of those 62 appeals. Okay, they're actively involved. And you know what? They have every right to be. And my feeling is on this is I'm not sure I'm quite ready to bring a hammer down and talk about how we change the fee process. But I wouldn't mind just, because I'm looking at, Mr. Emmons is here and Lori's here, and Mr. Emmons is obviously part of the leadership of Landwatch. I think it's important to continue the dialogue. But I'm hoping that maybe they can work with us in working with the legislature. That's where I think we can tackle a lot of this, so we're not constantly at loggerheads, because the difference is those who are really doing the developments in Lane County, rural Lane County in particular, are not major giant developers. They're family-owned something or another who want to do a lot line adjustment, a rezone to build something out there. They're not coming in and building a regional hospital. They're not coming in and building a high-tech firm. And I think that's the difference here is that, so you hear things like, well, the developers of this, developers of that. Most of the developers are local folks trying to make a buck. And so I don't necessarily like to hear this whole us versus them. What we should do is be talking about we. And this is really a great opportunity for those in the industry, Lane Landwatch, to say, what can we do to go to Salem and say, doggone it, you guys need to really make a change here, or else it's really going to put people out of business. And we can't afford to do that. And those are my thoughts right now on this particular piece, what we're talking about. But I got to tell you, the picture is much bigger than than simple fees. And what should we raise them or not? And so I'm not prepared to go there right now, but I'm going to continue to watch this and monitor, and my opinion may change in the future.
Thank you, Commissioner Lycan. And before I call on you, Commissioner Sorensen, and before we begin to wrap up the discussion today, just a couple of points I'd like to make. And, your time is finite. You don't have an unlimited number of hours. And I count at least 6 staff members in the room being paid to be here today. I'm sure that each one of them has something else that they could be doing. And as we move forward, we have to make judicious decisions regarding how we use our time. And the appeals process seems to be a non-decision. If it happens, you have to use your time doing that. The time has to be dedicated to do that. And, Ms. McKinney, you've pointed out on a number of occasions that Landwatch is a legitimate part of our community, that a lot of people count on them, that we respect them and work and respect their input and their work toward making certain we do abide by the 1973 legislative decision. That being said, any judicious person would look at it and consider the things that we aren't doing while we are responding by necessity to the appeals. And I'm by no means suggesting that we limit appeals by any stretch of the imagination, because it's been pointed out over and over again that this is a process that people have to legitimately challenge the decisions that are made by a governing body. And it's a legitimate process. But I'd like to be have it more closely delineated what it is that we're not doing while we are responding to appeals. Commissioner Williams has asked you for a general cost on a particular appeal or a general average on appeals processes. And one thing that I would like to have worked through is the type of work that our land use division is not doing while we are having all these folks sitting in the room working on what is a further manifestation of the appeals process. Commissioner Bozovich suggested this morning that we were talking about a camping ordinance which requires a Chapter 11, maybe a Chapter 16 revision, and we don't have time to do that. We don't have staff to do that. So at some point, we need to dedicate staff to making the decisions that are going to have far-reaching far-reaching effect on not only how we conduct ourselves as a government, but how people live in our county, how men and women and children who don't have homes are able to live someplace other than in a trailer that's being moved around the community. And if we're spending so much time on appeals that ultimately a vast majority of them are not being either reversed or altered, then what is the cost in the kids, for instance, who aren't able to go to school because they don't know where they're going to be sleeping tonight? And these are the decisions that we have to make as a land use division that we're not able to make because we don't have the time to do them. So I'm not saying that we alter the process at all. In fact, for me, the discussion is still open and we're gathering more information. But what are we giving up while we do respond to these appeals? What are we not doing that are discretionary for us? However necessary, discretionary but necessary. So that's a part of the discussion that I'd like to move forward with, should the motion be to continue until December 1st. So with that, Commissioner Sorensen.
Thank you. People in Oregon have been fighting about land use and land use planning for decades. And when our governor and our legislature held numerous hearings on the topic in the interim in 1972 and moving into 1973, the idea that the state would pass a comprehensive statewide land use planning that would unite Oregon's urban communities, Eugene, Salem, Portland, with the rural communities. Umatilla County came to will come into the story, was kind of far-fetched. That people would not accept limitations on their ability to change their own property and develop their own property. But through a unique compromise of urban and rural interests, that's exactly what happened. And Representative Stafford Hansel from Umatilla County, a Republican, a pig farmer, got together with urban interests, and Governor McCall got behind this whole effort, and all of a sudden in 1973, the Oregon Land Use, Land Conservation and Development Act, which basically was an expansion of the Oregon Coastal Land Use and Conservation and Development Act, was expanded. But immediately, the opponents of land use planning started a series of ballot measures to attack this nascent idea that we could build a better state, a better economy, and have the beauty and an integrated, economic system that would help everyone. And so the attacks were in 1976. Ballot Measure 10 failed. With 37% positive vote, 60% no. 1978, ballot measure 10 again sought to repeal ballot measure 100, again 39%. By 1993 and 1995, this is from Wikipedia, Republicans introduced multiple bills that stripped Senate Bill 100. Democrats stopped them. I was particularly involved in all that myself. Now we have a ballot measure to roll back 1998, ballot measure 65, roll back land use, failed. But the door was opened really when ballot measure 2 failed, but only by 3 points. And then Oregon citizens passed ballot measure 37. And that was in 2004. And 3 years later, ballot measure 49 repealed and set back much of ballot measure 37. So bottom line is people have been fighting about this for years. And to me, the issue is how do we not fight land use, but how do we comply and use Oregon's unique system of land use planning? How do we use that to make the community better? And one way, I think, is to do what LMD is doing now, and that is to provide information to landowners when they come in. Now, a few years ago, for commissioners' knowledge, we did not provide any funding whatsoever to LMD. We provided only the funding that the citizens brought in with them, a user system. Well, we changed that. And that was the system when I got here, but we changed that. We now give money that is paid by customers of the waste management system money into LMD. And what rough percentage is that now of your total budget?
It's probably close to 20%.
Okay, so we went from 0 to 20, and although that's not the end of the world and that isn't, life-changing, it has been rather substantial and does give what I would call funding of some sort to LMD so that you do not have to be in the user pays concept. Because after all, when the citizen comes in and asks, hey, can I build this shed? Can I, do this? Can I do that? Do we really want them to have to go through lawyers, with all due respect to our distinguished lawyers in the room, including me, do we really want to, make them do it? No, we don't. We want a more of a user-friendly thing. Well, I feel the same way about the appeals process. I really don't think that we should put up a big barricade, a barrier to somebody that goes, hey, I don't think that the government acted fairly here. I want another look at this. And to me, if we could figure out a way, when we talk about the subsidy, I mean, what's the subsidy? When a person comes in and asks for information from their government about what they can and cannot do, is that a subsidy to them? I don't call it a subsidy. Is it a subsidy that they have to pay a filing fee, but the filing fee doesn't cover the cost? I mean, to me, the answer here is not to put up the barrier, to recognize that there are costs and that they should be borne by the society that benefits from. And I would argue we have benefited substantially since 1973 with our land use system. So to me, the answer isn't to like single out, oh, the person coming in asking for information on their land and go, hey, the clock is ticking now. You owe us X cents per second while I answer your question. To me, that is like not a good system. And similarly, for the appeal process, to set up the barrier, make the barrier higher, make it more difficult, which in fact, that's the idea that's been suggested here. Make it, I mean, when it was suggested, it wasn't suggested by LMD to raise the fees. It was suggested by opponents of Landwatch. Hey, why don't you raise the fees and maybe they won't appeal so much? Well, to me, that defeats their whole argument, to me, because it's just showing that all they really want to do is stop local residents from going to a nonprofit group whose purpose is to assist them with this complex thing. And as to our criticisms of land use, of why this whole system has come to be and could we improve it, what is the Association of Oregon Counties doing to improve Oregon's land use? Do they write them letters and say, gee, we want to streamline? No, they've been part of the attack on the system. And in my view, if we want to be creative about it, we'll be making these suggestions. But just to repeal it and to attack it repeatedly the way the opponents of Oregon land use have done, well, fortunately, the voters thus far have said, no, they're not going to ruin the system that brings us the quality of life that we enjoy, most of us enjoy in Oregon. So to me, I'm always open to ideas of how to make things better, faster, make them more efficient. But what I'm hearing here is some people don't like it that people appeal government decisions. And some of those government decisions have actually been shown to be contrary to law. And why would we want to, put greater barriers? It's already an extremely technical field. I'm an Oregon lawyer. I have to do continuing legal education. Sometimes I listen to the land use programs that the Oregon State Bar has. Let me tell you, it's not for the faint of heart. It's complicated for the people that work in this field. So I think we ought to be very wary of putting up barriers to people appealing.
Thank you, Commissioner Sorensen. Very eloquently stated and very emphatically stated. I'm going to go to Commissioner Williams and Commissioner Bozovich, but first I'm going to talk about benefits. Benefits are not the same to everybody, and not everybody sees something as a benefit that other people see as a benefit. Now, we all benefit from Oregon's land use laws. There's no question about that. People would agree with the fact that we benefit from it. But any benefits come with a cost, and they also come with a counterbalance. What is a counterbalance to the really the nation's strictest land use laws. Well, what is the counterbalance to that? Well, we find, for instance, housing costs are a lot higher in Oregon, documented, actual, factual. I know a professor at Lewis and Clark who sold his townhome in Portland for $400,000 and bought a Victorian mansion, so to speak, in the center of Ohio for about $100,000. Now, Ohio probably has much lighter land use laws than Oregon that allow more overbuilding, so to speak. But that being said, as we move forward, the thing that's important to me is that when people do make the good decision to adhere strictly to our land use laws and to not diminish the land use laws in any way, we need to fully understand what is the balance to the land use laws that we have. What cost do we incur because of it? And when I say cost, I mean the price of our children not being able to buy homes in the towns, in the cities and communities that they grew up in, having to go someplace else in order to do that. That's a cost. And it is a factual cost when wages don't go up with the price of housing. And our land use laws, how much do they contribute to the cost of housing? So that's the decision that has been made, and it's not something that's very easy to reverse. But people, if somebody says to me, do you like clean air? Well, yes, I do like clean air. Do you like clean water? Of course I like clean water. Do you like being able to drive in the countryside that's only 1 mile from your front doorstep? Of course I do. And then, but based upon the fact that I can have that basically at no cost, that's great. But if there is an inherent cost in having those great benefits that I enjoy, that we all enjoy, that we all covet, so to speak, then we need to have a clearer understanding of what the balance is. And as we move forward with this discussion, Commissioner Lycan suggesting a longer-term legislative addressing of the issue. That's probably due to come. But in the meantime, we're here talking about the finite resources of Lane County and how do we manage the finite resources of Lane County. So thank you. Commissioner Williams and Commissioner Bozevich.
Thank you, sir. One of the things that occurred to me during some of the discussion here is that oftentimes I hear, and I heard this as a mayor for a number of years, the time it takes to process building permits. And I know that's an issue at the county as well. If we're chasing after some of these other situations that exist that are taking away staff time to be more expedient on the permitting process for people to be pounding nails, for lack of a more succinct way of putting it. But we know the cost of buying a piece of property. We know the cost of permits. We know the cost of building a house before you pound the first nail. And so one of the things that's really frustrating for the developer, the home builder, whether they're just building their dream house or the person is building tract houses, really doesn't matter to me in that sense. It's the fact that the permitting process is a slow process. And when other things encumber that process, slowing it down more, then that to me is problematic. And so some of the discussion that we have been having today clearly indicates to me that there's a lot of frustration revolving around permits. In my 16 years as in municipal government, that was probably the thing that I heard as much about as anything is, why does it take so long to get a permit? Well, because you're doing different things, and it's all important work. But there needs to be, in my view, an emphasis placed a little bit more fairly and squarely. If you look at the amount of if you look at ratios of the 300 some odd thousand citizens in Lane County that are paying taxes, and there is less than 1/100% of people going through some sort of appeals process, I'm a numbers guy, and I look at that, and I think there's a discrepancy here, and a prioritization issue. So just thinking about some of those things that I've heard, and I'm questioning and concerned about. So, thank you, Mr. Chair.
Thank you, Commissioner Williams. Commissioner Bozievich.
Thank you. So first I want to clarify one thing. The tipping fees that come to land management, they are collected for a specific purpose and are restricted in their use, I believe. Is there somebody that's willing to really quickly address that? They're not available for appeals.
That's correct. When the board allocated tipping fees a number of years ago, it was specifically earmarked for administration, technical services, customer service, and long-range planning. So the one thing that was excluded was the general permitting application types, and appeals are associated with that.
Thank you. I just wanted to make sure that was understood as Commissioner Sorensen was pointing out that there's now 20% of your budget comes from the tipping fees. It does not cover this particular issue we're talking about. And without those tipping fees, we wouldn't be doing any long-range planning right now, basically, because that's completely what's funding our long-range planning work plan, which is where we're doing code revisions, Envision Eugene, Springfield 2030 plan. All that stuff happens out of that 20% that we're getting out of tipping fees.
And code compliance also, Commissioner Bozievich.
And code compliance. So yeah, there's that money is not unrestricted, and it's being utilized. And it's not being utilized to support this second appeal. That's one thing I want to also make clear, is we're not discussing the first appeal of a land use decision. We have a very set state statute that says we can only charge $250 for that, and that's what we do. So to get your first appeal of a land use decision because you disagree with it, all you have to do is pay $250. We're talking about the second appeal today, and the subsidy to that second appeal. And yes, people have a right to appeal. And that's one of the reasons why I struggle with the idea, if somebody does appeal and they prevail, whether they should have to pay some outrageous cost to do so if they were right in the first place. But if they appeal and they're not correct, I do have concerns that the system is being utilized as a delay tactic.
Thank you, Commissioner Bozievich.
And I want to finish this, because one of the things that was stated in some of the letters is it's all about these rich developers. Well, with the exception of one or two folks that are processing land use permits out there, a lot of them are families. And they have a right to an expeditious process to get to where they can actually enjoy the use of their land under the legal constraints of our land use laws. And when they're being appealed constantly, whether it's replacement dwellings, template dwellings, marginal lands, you name it, we're seeing appeals for it. We have to start thinking about that process and why we're allowing a subsidy for a particular constituency, and at the same time denying expeditious process to another.
Thank you, Commissioner Bozievich. And moving forward to what direction do we want to give to staff at this point in time? We have a couple of options. One is to move to direct you to continue to monitor and nature the number of submitted land use and return to the board by the end of the year, by December 1st of this year. That's one option that we have, or move to take action today. So to the board, I've heard a number of people talk about getting more information, hearing more information regarding the cost and regarding the delays involved. Does the board feel that directing the Land Management Division to continue to monitor and gather more information and come back to the board with a report by December 1st, is that an appropriate direction for us at this point in time? Yes? And I hear no objection to that.
Yeah, I think that's reasonable.
I don't believe you need a motion. That's just a direction. Just let's gather more information based upon the input that you received from a number of commissioners today, and bear in mind that you may receive further input, questions that you can address between now and December 1st, and we'll anticipate having another discussion in early December regarding this issue. Ms. Mokrajewski, does that cover the directions that we're looking for today?
I believe so. Yep. Thank you.
Okay. Well, thanks for a long discussion. It was a good discussion, and without particularly any resolution at this point in time, but certainly more things to look at and more consideration. Thank you very much, and thank you for all of you attended and paid attention today. So thank you very much. Give the room a moment to clear.
Back into exec session.
And
or you want to do commissioners' business and stuff first?
Let us move along to let's go push it more toward the end of the agenda, Mr. Mokrajewski. And do we have any commissioners' business at this point in time? We do have an executive session, subsequent to which we will have the option of returning into regular session. Commissioner's business, Commissioner Lycan.
Thank you, Mr. Chair, and I'll try to be brief here. So yesterday I was in Salem, and so Commissioner Bozovich, my apologies for missing the facilities meeting, but
It was thrilling.
I bet. But anyway, I was notified ahead of time. I was in Salem yesterday, mostly talking transportation, and able to meet with our members of our delegation, talking about the potential transportation package, and really hitting on territorial highway, the jurisdictional transfer there, what's written, because what's interesting about this package is that the legislators are actually putting in earmarks in this state package, so it's pretty interesting how they're going about doing it. One thing we did find out is there was $25 million mentioned for Lane County for a transload facility. Lynn County screamed, and so there's probably going to be a change in how that's, so it won't be dedicated to Lane County, but instead won't be dedicated to Lynn County either. So they're probably going to create where $25 million is dedicated to a Mid-Valley or Willamette Valley transload facility. I had a great conversation with Cindy Robert, as some of us know. She's a very influential lobbyist with Union Pacific. And she actually told me she wants to come down here and have a look and see what the potential is. When you're talking about the Class 1 railroads, they want to move product between the Oakland and Tacoma. That's what they want to do. That's how they make their money. And the less stops, the better off. That's what they're looking at. But I think it's worth having that conversation. I actually think we're in a better position than Lynn County to have what I would call a successful transload facility. That's just overall because of where that would be located. Also testified before the Joint Transportation Committee on behalf of AOC and myself, Commissioner Pope, and also John Viles, the Public Works Director down in Jackson County. So we were the county reps. And we testified last night, and in fact, a lot of folks did. It was a packed house, as you can imagine. And so we'll see where this goes, but it was pretty exciting. And also got a chance to touch base with Betsy Einhold, who used to work for ODOT, and now she happens to be Senate President Courtney's Chief of Staff, and talked to her a little bit about courthouse. And she's very receptive of what we're doing here in Lane County. So nice to have the ear of the Senate President's Chief of Staff. I'll leave it at that. Thank you, Mr. Chair.
Thank you, Commissioner. Further announcements? Commissioner Williams?
Two short items. I had the pleasure Sunday of attending the 100th anniversary of the Goshen Grange. And that may not mean a whole lot to a lot of folks these days, but to my fellow commissioner in the rural routes, commissions or Granges are one of those entities that still exist, but they're fading away. And that'll segue me into another topic of fading away. Today is June the 6th, and We should remember that.
Yep.
Thank you. Further announcements? June the 6th was a particularly big day in England,
And
especially the
France.
south part of England and the north part of France, absolutely. For anybody who's listening who doesn't recall what happened on June 6th, see, what was that day called?
D-Day.
D-Day. So it's, the world changed that day. So, further announcements. I see none. Any agenda team requests or work session requests? Mr. Mokrowski received none so far. Then we'll move along to review of assignments. Now, we may have further assignments after the executive session. Should we come back into session? Any assignments to review at this point?
I have two. The first was we'll bring back a board order to appoint Commissioner Lycan to the Forest Management. Is it the Forest Management Subcommittee on Public Lands?
Yeah, for AOC. Yeah.
For AOC?
Yeah.
Right, okay. But it's the Forest Management
Subcommittee to the Public Lands.
Subcommittee to the Public Lands Committee of AOC.
AOC,
Okay.
yeah.
Now we have it. So we'll try to get that on the agenda next week. And then the other item is a report back with options for a pilot project related to temporary shelter, emergency shelter in the urban transition area, consistent with our existing code. And we talk to staff afterwards, and we'll meet to discuss what structure that can look like. So I don't want to put any more meat on the bones yet, but we'll report back to the board likely in August on that. That's all I had.
Very good. At this point, then, give me one moment. Is there any further business before we retire into executive session? We'll be returning into executive session, after which we will potentially step back out into regular session for potentially a HR item subsequent to the executive session. So the Board of County Commissioners will meet in executive session to consider the employment of a public officer, employee, staff member, or individual agent, and to conduct deliberations with persons designated by the governing body to negotiate real property transactions. 2 items. This executive session is held pursuant to ORS 192.6602A and E, which allows the Board of Commissioners to meet in executive session for the purposes listed above. Representatives of the news media and designated staff shall be allowed to attend the executive session. All other members of the audience are asked to leave the room. Representatives of news media are specifically directed not to report on any of the deliberations during the executive session, except to state the general subject of that session, as previously announced. No decision shall be made in executive session. We reserve the right to come back out into public session should the need arise. Subsequent to the gavel, we'll recess the regular meeting of the board, enter into executive session. Subsequent to executive session, if we do come back into regular session, we will remain in the BCC conference room. I will reconvene this regular June 6th meeting of the Board of County Commissioners. We have before us consideration for a recommendation for a performance audit of the performance auditor position. Commissioner Bozovich.
Thank you. And after the interview process and reference checks, I feel comfortable in making this motion. I move that the board approve the appointment of Ian M. Green as performance auditor and direct the Human Resources Director to negotiate employment terms and authorize the board chair to execute the final employment agreement.
Second. Moved by Commissioner Bozovich, seconded by Commissioner Lakin. Discussion to the motion. Commissioner Sorensen.
All 5 commissioners participated in both the interview of Mr. Green and also a discussion about his answers to various questions. And I felt like he really looks like an excellent candidate to succeed Ms. Miller. And I think this is a good motion to get the process going and get a discussion and negotiation over terms of his employment. So I think it's a good move.
Thank you. Further discussion? I see none, then I'll call for the vote. All those in favor, please say aye.
Aye.
Opposed? Passes unanimously. Thank you, Mr. Miller, for bringing us to the point where we can make a good decision such as this, and Mr. Mokrahayski for guiding the process. Is there anything else, any further business for the order of the agenda? I see none. We are adjourned.